joining us today. We were live a little bit. We thought we were live, but a new platform today, and I hit the wrong button. We were going for about 7 minutes before I figured out we're not live right now. But now we are live, and unfortunately, we did answer this question that just came in here. We were talking about this one right here, and I think actually it makes a, you know what, this is a really good introduction to today's topic. So joining me today is the great John Richardson, and John created a wonderful presentation on the Moore decision, which just came out on Thursday, to help us decipher what it means, good, the bad, and the ugly. And again, here's the first comment we got for today, and I think this is a really, really good place to start. My opinions on what Trump could repeal citizenship-based taxation, you know, it's within the realm of possibility, but in order to do so, and this is really what I focus on, is some of Trump's key decisions he made at the Federal Reserve. He put a lot of his own people in there, and it seems like something's going on there. And I would say for any relief from citizenship-based taxation, something has to happen to the Federal Reserve. Again, these laws were passed within 2 weeks of each other. They work in conjunction. The federal government gets all the revenue it needs from the Federal Reserve. It doesn't need our tax dollars. It does not need it at all. What the purpose of the IRS is to destroy the excess dollars the Federal Reserve creates so that hyperinflation doesn't occur and that inflation generally stays predictable and inevitable. Right now, we're maxing that out a little bit because the spending went a little much, right? And so in order to reduce that inflation, there's really one thing you have to do is just confiscate a lot of wealth. So that's one thing there too, but I would say it's possible. But here's the thing to understand is who signed in the law. John Richardson, the great John Richardson, coming to us from Toronto, Canada. Who signed in the law, the transition tax, John?
Well, there's no question it was signed by President Trump in December of 2017.
Yeah.
But to add to that, I mean, the law itself, you know, this stuff was under discussion in a very significant way since as early as 2014. It was clear that, basically, the corporations needed to get a tax rate reduction. At 35%, you know, the U.S. was completely non-competitive, okay, plain and simple. And what happened was that, you know, companies were putting a significant amount of their ingenuity revenue, you know, into creating an effective tax rate less than that. And there was also the CFC problem, you know, namely that the U.S. wasn't directly taxing the profits of foreign corporations. So you have a company like Apple, and they'll have billions of dollars that were earned through foreign corporations, never taxed by the United States, sitting there, and they're afraid to bring it back because if they bring it back in the form of a dividend, they're going to be hit with, you know, a 35% confiscation. Nobody in their right mind would do that. So, you know, the lockout effect was largely because of the 35% tax break. So tax rate. So the way I see this was that basically the corporations got a massive reduction in their tax rate to 21%. That's what they got. And what they gave, was you know, we're going to agree that these retained earnings in foreign corporations can now be subject to U.S. tax, but at a much lower rate than they would have, right? So what this is largely, it's a business deal between America's multinationals and the federal government, right?
Yeah. Yeah, and it's again the individual without representation was who got screwed by Congress, right?
Well,
it
was individuals, Americans abroad who really got screwed because remember that the S Corp lobby was able to secure a very, very good deal for members of their association. In other words, individuals who were shareholders in U.S. corporations who, you know, owned these CFCs or, you know, were able to change their designation, their tax designation to an S Corp in order to avoid the transition tax, right? So that whole group was taken care of. And the ones who were clearly hung out to dry were U.S. citizens living outside the United States, which is clearly numerically the largest number of these corporations. Not even close, right?
Yeah.
And they were basically they were hurt so badly. For example, in Canada, many people were using these small business corporations as private pension plans. And the bottom line is this is the simple fact of the matter, okay, that the transition tax confiscated the pensions they've been trying to create all their lives. So, that's what it really was. And what's interesting about it is that so Americans abroad are what, Justice Stone would have called a discrete and insular minority. In other words, nobody cares about them, no political representation. We don't need to worry about the effects on them. This destroyed their lives in return for basically a tax cut for U.S. multinationals. That's the bottom.
There we go.
And
there we go.
This is why, the combination of this, plus last week, Democrats abroad making it clear that they're not willing to advocate for severing citizenship from tax residency, at least in the short run. My advice to people is get out, renounce U.S. All roads lead to renunciation, and now I've added the word now. You're a fool.
Now, and by the way, that is for it's, and I think when we say that, we're qualifying that if you're someone who's on the fence of it, for some people, renunciation just isn't an option. But if it's something you're thinking about and you're wondering, right now is a fantastic time to get out, as it seems to be getting worse and worse.
There is no reasonable prospect for relief on the horizon. I want to also note before we get into that. The way the decision was written in Moore, okay, not a single opinion anywhere made a single reference to the difference between individual shareholders versus corporate shareholders, much less any reference to Americans abroad. Okay, I mean, and this is true notwithstanding the fact that at least two of the briefs, the amicus briefs that were submitted, our seat, and another one that included the Suzanne Herman story, all right, were specifically there to educate the court with respect to how this affects individuals generally and Americans abroad specifically. They ignored the whole thing. Now, let me explain to you what I think happened before we go through. Obviously, these judges don't care about Americans abroad, but they aren't so unprincipled that they're not going to, consider the issues that they think are important. But imagine that you're, on the Supreme Court, and here's the dilemma, right? On the one hand, it's pretty clear the way the appeal was, the way the cert petition was framed, etc., that the real issue was that the litigants wanted the court to rule that income taxation requires actual realization. Okay, they wanted to do that partly to get ahead of a wealth tax, but also, if you look at the Biden Green Book, for example, there are all kinds of things in there about deemed sales of gains, this sort of stuff, right? And they wanted to get ahead of that. And then, of course, we have the 877A exit tax, which is another problem. So what they really wanted was for the court to rule that income can't be, that it's not income unless it's realized. They weren't really concerned with the transition tax, okay, per se, right? They were concerned with a ruling going forward that income requires realization. And I've got to tell you that I think that they were 90% successful in getting what they wanted, even though they may claim it's a loss, because what happened was that of the 9 judges, 4 of them very specifically ruled that income does require realization. Okay, and these would have been Justice Thomas, Justice Gorsuch, Barrett, and Alito. On the other side,
John, I think maybe we want to get into the presentation. Why don't we hop into the presentation now? Because we're going to get into that. I want to ask Keith. Yeah, Keith, go ahead.
Yeah, I'm sorry. I do need to ask a very fundamental question here to go back to when you said about renouncing, which I agree with you. However, if you happen to be an American overseas who has an entity that's deemed a CFC, and you are either current with your U.S. tax filings, or you're going to be current with your U.S. tax filings to have a clean renunciation, how is that going to help you? Because you still have to deal with the transition tax. You see what I mean? So you're still getting screwed. You just won't be getting screwed moving forward. Do I have that correct?
Well,
You see what I mean?
sort of, not really.
Yeah, Keith, you know what? Keith, I see your question, and it's something. Keith, I see your question because the transition tax, and this is something that we haven't encountered a lot because it just doesn't come up in our fact patterns much because of the way who decides to come clean and for what reasons why. The transition tax was passed in 2017. Now,
Right.
let's suppose that somebody wants to clean up they want to certify 5 years of compliance.
Right.
Right.
Yes.
Okay.
To renounce. Yes.
Let's say, well, it's in 24. So 24 will have to be one of those years. So 24, right. 23, 22, 21, 20.
Okay, so it's only the 5 years. So even though the transition tax is retroactive to 1986, if you are that American overseas and has had a business, let's say, for 10 years, it's only the 5 years of backfiling. It's not going to go back on the transition tax to those 10 years that you've had your entity as a CFC.
And I just want to be careful. I have not done that, and I have not researched this. It just this fact pattern has just not come up for any of our clients. But that would be something that, and I think that's just an additional confusion. Well, I'm not in compliance with this 2017 law, and how would you even file a 2017 return at this point? If it's, well, assuming that you filed already, it'd be hard to. So I'm not sure exactly. I mean, this is again, Keith, what you're expressing.
Yes.
My entire what is actually my entire point about this entire Moore thing. It's just and I think what I'm going to get to is, and I just think that the Supreme Court is pretty much of a failure. And if you actually think about what the purpose of the Supreme Court is supposed to do, I think I think John's going to make my case for me. So why don't we get into the first? Why don't we get into the first?
Before we get into the first slide, listen, you're really complicating this. Okay, I think the bottom line is simply this: on the renunciation, you're going to certify 5 years of compliance. Basically, this goes back to 2017, 2018 filing. Okay.
Right.
So,
okay.
Strictly, but if you're trying to come into compliance, I would note that the streamlined procedures specifically say that if there's a transition tax issue, that has to be dealt with. Okay. Anyway.
Thank you, John. Thank you. Then I think now. Yeah.
We're not here.
However, but John, whoa. Hang on a second. I have something to add in there. You don't need to use the streamlined procedure to certify 5 years of compliance.
That's right. That's what I was saying.
That's right. Oh, I'm sorry, John. I didn't hear you. Right. You don't need to use it. You use the streamlined compliance to limit your future penalty assessment. But if there's a case where you're renouncing, you might not do it. So thank you, John. Thank you very much for that. Okay. All right. So let's so your first slide.
Thank you.
Yeah.
Listen, can we just stop here for a minute? This is a ridiculous discussion. It really is. I want to make it very clear that people need to get competent individual advice. Okay, this is a big issue. It's not like you're going to get an answer to this question.
No, but it is a question that does come up with people who contact me. So that's why I wanted to bring up the question.
Get competent advice. That's the answer. Seriously.
I get it, of course. But
all right, John. Again, I'm checking a box because you're making my case again. There's a checkbox, John. You're making my case again because this conversation is ridiculous. It really is. What we're discussing is utterly ridiculous, and how much thought that has to go into this, how much great thought, how much intelligence needs to go into deciphering what this all is. This is this is such a mess. This is where I would say the Supreme Court has failed for so long. The Supreme Court has failed for so long because what it does is it likes to complicate things, because in that confusion is more power, more things to go. And so the Supreme Court has been the chief confuser in charge. And that's why we're at this completely absurd result. And I think this case really, really proves how absurd the Supreme Court was and I think unhelpful. They really didn't do too much, and everybody can find something to pick from, but ultimately it's uncertain, and you have people with no unified front. We don't know what the real decision is. So, all right, John, let's go with your first slide here. What the
Okay, so we need to begin with an understanding of what the transition tax was. Do you want me to explain it, or one of you two? But that's where we need to start.
I like my explanation a little bit. So
Cool.
what the transition tax, this is what the transition tax did. That if you were a shareholder in a corporation, a foreign corporation, and you're a minority shareholder, you just had some shares in it. That what the code did was they looked past you into the shares of the corporation that you owned to say, well, how much retained earnings, that's a good way to put it, did this corporation have? And then what the law does is like, well, this corporation, which by the way is full tax compliance with all the tax laws of the country it's in, this company, well, they have built up retained earnings. And because they have built up retained earnings, if we take what your pro rata share of those retained earnings are, we could see that, hey, buddy, you got unearned, you have income to report. Now, here's where I find the problem with that. Number one, you are piercing the corporate veil. The tax code is piercing the corporate veil. You're saying that, whoa, that retained earnings belongs to the corporation. That belongs to the corporation. A shareholder can't just go in there and say, oh, wait a second. Hey, how much money's in the bank account? All right, well, hey, look, I have this much a share, so you better give that money over to me. It's like, no, that belongs to corporations. So this is what I find truly obnoxious about the transition tax, that you become liable for someone else's gain. And that someone else's gain, they're not even part of the US tax system, for crying out loud. They're not even part of it. But now you're liable for their gain, and that gain is not your gain. It is not your gain in any way. And you would be arrested. You would be arrested and put in jail if you try to get that money because it's not yours. That would be embezzlement. But that is what the code does to you. It assumes you have a legal right to embezzle money, and then we'll tax you on that embezzlement. And that's why I term the phrase vicarious realization. And that's what I find so dangerous about this Moore decision, that no one could see this. They can't see that someone else is being taxed because someone else had a gain. And now with this, we've sort of crossed the Rubicon, if we can. So now anybody could be taxed for anyone else's income. That's what Moore stands for. You could be taxed because someone else had income. Isn't that nice? So that's where that's my interpretation of this. John, am I wrong? Am I wrong anywhere in that?
No, you're not wrong, but here's what it says. Okay, basically that if you are a U.S. shareholder of a controlled foreign corporation, now without getting into too many details, that would mean an American citizen living in, say, Canada, who's the sole shareholder of a Canadian-controlled private corporation, which is very common. And if it has retained earnings, okay, then basically the full amount of those retained earnings from the period of 1986 to 2017 are subject to an income inclusion for you, the shareholder. In other words, they're going to attribute the corporation's profits to you. That has to go on your tax return as ordinary income, and you have to pay tax on it. Okay, so in other words, what it is, all right, is a retroactive tax on income that you never received. Okay, present.
Well, now, John, now correct me. I did not
receive.
I don't know if this was a CFC. That's what was, because this was, and that's what I think threw me off, because that's, it's not really subpart F income because it's not a CFC.
Well, this is section 965 of the Internal Revenue Code, sections 951 to 965. That is the subpart F section. What 965 says, okay, with a hell of a lot of text, but where it goes is it says that these past earnings of the corporation that you're a shareholder of are going to be included in your income under section 951. That is subpart F, right? So in other words, what they've done,
oh,
they've created, sort of a new category of subpart F income. But It's really problematic for a lot of reasons. But let's just be clear.
All right. Thank you, John. Thank you.
On what it is, okay. I mean, we all agree it's a horrible thing, but I think what people need to understand is that one, people were required to pay tax on money they never received. Now, that would be horrible even going forward. But two, not only that, but the money they're being asked to pay tax on was earned by a corporation in the past during the period from 1986 to 2017. So that's why it's current taxation on retroactively deemed income, if you will, right? That the person never received. So let me give you a very common example. You know, a few days after that came out, a doctor in British Columbia called me who just retired from his practice, and he had, you know, I mean, many doctors in Canada run their practices through these professional corporations. He had about $3 million in retained earnings. He just retired. The point is, basically the full $3 million was subject to current taxation by him, right? He was going to be taxed on the $3 million. Now, I agree that it wasn't at the same rates as other income, but that's how it's taxed, not whether it's taxed. The point is that all the corporation's income, which is the corporation's income and not his, he was required to put somebody else's income on his tax return and pay tax on that. And to make it worse, I mean, that's bad enough in present day time, but go back 31 years. Okay, how would you like, Anthony, if, you know, somebody knocked on your door and said, you know, I'd really like you to first determine what your father's income was for the past 31 years. And by the way, would you mind just putting that on your return this year so you can pay tax on it?
Yeah, there you
that's
go.
what it
Right on,
is.
1986. That was, yeah. That was 15 years old. That was a long time. Right. And that's how far, you know, I'd have to go back there.
Well, I mean,
pretty crazy. And I mean, I do want to move. We got a lot of stuff to get to. I want to push you through these slides,
Right.
and save some. So I got to save some of my commentary. All right. So here it is.
Understand, the reason I call it the good, bad, and the ugly is because it affected different groups in very different ways.
Yeah.
The multinationals loved it. It was just the deal they made, okay, you know, to get the lower tax rate. I mean, Anthony, how much would you pay, you know, in order to get your tax rate cut in half on an ongoing basis permanently? It's a business decision, agreed?
Yeah.
Notice that not a single multinational supported the Moors or an attack on this. They're perfectly happy with it, okay?
Yeah, they think it's great.
Now, individuals, you know, U.S. resident individuals, you know, it's of course bad, okay? But many of them who ran their businesses through S corporations, you know, got a sweet deal in the code itself. All right. And the ugly, of course, though, was Americans abroad who never got any deal of this kind at all.
Yeah.
Okay. And
In
whose lives
particular, yeah, exactly.
were by this, right?
Right on, yeah.
So there you go.
There it is. Yeah, that's the good, the bad, and the ugly here. And I think this is where I'm at. This law is so terrible bad. The fact that it's even at the Supreme Court, the fact that it's even necessary to go to the Supreme Court is somewhat of an outrage. And the fact that it went to the Supreme Court, and then we have the most jumbled, nonsensical opinion that gives us no guidance whatsoever. I mean, the whole purpose of the Supreme Court is to have a supreme law of the land. Well, what's the supreme law of the land? Not entirely sure here. I'm not entirely sure what you advise someone based on this entire jumble. The Supreme Court could not find any unity, could not find any way to help anybody trying to understand this. Rather, in their confusion, they just created more work for themselves and for others to go through. John, you still with us? I know you said you had you might have some internet things going on later today. All right. I think John's still with us. I hear the birds chirping in the background. So we'll move on to his next slide here. A snippet of Justice Barrett's decision that discriminates against U.S. citizens abroad. And, you know, I did notice Justice Barrett was really concerned. She was really concerned, like, well, you know, if the government can't tax, then there would be limits on government power. She was very concerned about that. Like the same concerns Justice Jackson had on the First Amendment, really hamstringing the federal government. So too, Justice Barrett is really upset about the Constitution, the constitutional protections hamstringing what the government wants to do. So pretty interesting thing there too. I don't think. Oh, there he is, John. You're back.
Yeah.
All right. Are you back for good, or are you back indefinitely?
I'm okay. So, look, I think it's really important to understand that the majority of taxpayers affected by this were Americans abroad. That was clear to the court from the amicus briefs. They were completely ignored. But it's interesting to me that Justice Barrett's decision, joined by Alito, they specifically mentioned the fact that these are foreign corporations, gives perhaps a better reason to attribute the income from the corporation to the individual. Now, obviously, this is very, very discriminatory for Americans abroad who are in no sense running a foreign corporation, right?
It's just insulting. Yeah, insulting. And again, when we talk about we have the Fifth Amendment due process clause, which says that the federal government must give equal protection to everybody under the law. And then again, our tax code starts off with discriminating, and the tax code is nothing but discrimination. That's entirely what it is. It is a discrimination code, is what it is, and that is the true Constitution of the United States of America, by the way.
Okay, now this is really important, okay? Because look, let's just pause.
Here it is. Yeah.
Close your eyes and let's imagine the context here. On the one hand, this is a court that I think probably mostly is going to be anxious to forestall wealth taxes or things in the Biden Green Book, where they can be deemed sales of capital gains, or the Wyden thing, et cetera. But on the other hand, they really don't want to reverse the transition tax. And they make it very clear at the end of the majority opinion. And this is where I think we should start. I mean, this is, I believe, shocking, right, as a justification for the decision. But they end by saying, and these tax provisions, if suddenly eliminate, would deprive the U.S. government, the American people, of trillions in lost tax revenue. The logical implications of the Morris theory would therefore require Congress to either drastically cut critical national programs or significantly increase taxes on the remaining available to it ordinary Americans. What a total crock of shit. I mean, this just shows you that these people have no connection whatsoever to the real world. But the bottom line is, that here's their dilemma. On the one hand, they have to make sure the transition tax is upheld for the reasons given here. On the other hand, they are inclined to use this opportunity to the extent possible to make claims about the possible unconstitutionality of certain taxes coming because they don't necessarily require realization events, right? Now, bear in mind, the issue before the court, is, and I'm just going to put it contextually, is whether in order to qualify as income under the 16th Amendment, there has to be realization. That's the issue. And so we'll talk about here now how the court managed to thread the needle. On the one hand, make sure that the American people were protected by all these additional tax revenues, but on the other hand, send a signal to lawmakers that no wealth taxes, and no deemed realization events. So let's go through how they did this. This is quite interesting. Next slide.
Well, John, this is what I want to bring up. And again, Justice Jackson was ridiculed for saying, the First Amendment really hamstrings the federal government. She was rightfully ridiculed. So she's somebody who doesn't understand. Well, that's the purpose of the First Amendment. The purpose of the First Amendment is because the federal government has only limited powers. It can't do everything, dear. It has only limited powers. And the First Amendment is one of the ways that the federal government is limited, which offends them. Now, a lot of conservatives mock Justice Jackson for this. But now we have Justice Barrett ridiculing, it's demolishing herself, soiling herself. And these other justices can't wait to sign on to this, because here she's saying is that, you know what really gets in the way of the U.S. government collecting as much revenue as it wants? The Constitution. And you know what we got to do? We got to get rid of it. That way we can get more money into us, because here it is. And I mean, how obnoxious is this statement? And those tax provision, if suddenly eliminated, would deprive the United States government and the American people of trillions into lost tax revenue. Here she's equating the U.S. government with the American people when we are clearly at odds. And I guess the Moors aren't American people. They don't count, because I guess they're overseas, and so they deserve the full brunt of the government and whatever they want to do. So I look at this as, conservative justices, they all missed the boat. Whatever's going on in law schools today, whatever's going on, it's all a worship of federal power above all and above. And so much so, they'll actually say, well, that's really the American people too. So, I mean, just unhinged. We have a Supreme Court totally out for forces other than the people they are supposed to represent. Rather, they are there to protect the federal government from the people who don't want their money confiscated for reasons they don't agree with. All right. Thank you, John.
All right. So again, here's, the court's dilemma. Okay. So now what's fascinating here, what's really fascinating, is actually the best parts of the decision for anybody who wants to read it are in the footnotes throughout. Right. But now let's just put this again in context. So they don't want to strike the transition tax down, but at the same time, they want to send signals, or enough signals, that income requires realization. Okay. I'll be back.
That island tone, right? So we're going to move on here. And so here it is, and they're trying to thread the needle here, and really what they're doing is they're just taking the entire Constitution and putting through a wood chipper, really, and we're just getting a paste of wood pulp at the other end that we're supposed to say is justice. But really, they're trying to invalidate. They're trying to find a way that would avoid a wealth tax while still allowing for a transition tax. And I would say this is that the what happened in the Moors wouldn't even be a wealth tax, because it was somebody else's wealth. Not only it was somebody else's wealth, the retained earnings of a corporation, and somebody else's earned income, the retained earnings of another corporation. So here it is. They're trying to find this way to get exactly what they want. I think maybe politically to say, yeah, we don't want a wealth tax, but of course, hey, look, trillions of dollars. Hey, Justice Barrett, trillions of dollars of revenue are lost to the U.S. government, American people, without a wealth tax. I mean, shouldn't we be concerned about that? That might be a question. John, what to add on this slide here?
Okay, so here's what I think is critical. In the lower courts, there were two issues, right? One had to do with, generally the realization issue. But the second was the retroactive nature of the law, which, is a very, very serious issue here on due process grounds. Now, what happened was that on the cert petition to the Supreme Court, for reasons that I think I understand, they abandoned the retroactivity issue altogether. To me, that's evidence they weren't really concerned with the transition tax. They were concerned only with the realization event. Now, had they been concerned with retroactivity, that's the type of issue that would have allowed the court, I think, to strike down the transition tax and avoid any decision on realization whatsoever, right?
And you've been saying that for months on this channel.
Yeah, for
again
sure.
and again. You've been saying that very clear. Here's a clear way out of this where we don't have to get too much into. You've been saying that for a while. Absolutely.
Yeah, they knew that. Okay, they knew that. So they deliberately decided to not consider the retroactivity issue, because by not considering the retroactivity issue, it made it much, much harder to attack the transition tax, right? Okay. Now, what's fascinating in footnote, in other words, what they're doing is they are deliberately disregarding the one issue, or the issue that I think would primarily allow them to get rid of the transition tax. So they decided they're not going to do that. And they did that
Yeah.
as a way of rationalizing, upholding the transition tax and continuing to focus only on realization. Now, in other words, as I tried to write it here, theoretically, and I think let's just move on here a little bit, because this is what I think the context of this is. Now, here's footnote 6. Now, this is fascinating, because they acknowledge that they could have considered retroactivity, but say that under court precedents, it's unusual for them to do so. Therefore, why do so? Now, this is right here, footnote 6, right? The MRT applies to income that was realized and accumulated in the past by foreign corporations, but not taxed by the United States. In the lower courts, the Moors raised a due process retroactivity argument, et cetera, et cetera. Then they say here, okay, and the Moors did not seek certiorari on that issue. They'd really been concerned with the transition tax. They would have. Now, this quotation comes exactly from that case. I checked this. We do not normally consider a separate legal question not raised in the certiorari briefs, and see no reason to make an exception here. So the effect of that, if you will, was to basically allow them to disregard what would have increased the chance of their striking down the transition tax, and actually treat it as though it was not a retroactive tax, when in fact the most egregious thing about it was the fact that it was a retroactive tax. But anyway, moving on.
Well, John, I mean, and again, I just want to clarify, it was not it was the Moors attorneys themselves who failed to request that issue.
Exactly. The cert petition did not, they abandoned the retroactivity argument in their cert petition in the Supreme Court.
Okay, that is really bad, interesting, and makes me question, honestly, that makes me question the loyalty of the Moors' own attorneys. Well, that makes me really question
loyalty to what? I mean, I don't think that they were concerned with the transition tax. They were concerned with the principle of realization. Is there a realization requirement for income to be constitutional? Okay.
What? This case is making me ask way too many questions now. Yeah, it's as if you wanted to lose. You wanted to lose. And as you've been saying,
they didn't want to lose. They didn't want to lose, but they wanted to keep the court focused on the issue of realization. My point is that by abandoning the retroactivity argument, what they did was made it much easier to uphold the transition tax generally, and really focus the argument only on realization, which is, I think quite obviously what they were more concerned with, right? I mean, this litigation was not brought for the Moors to get their $14,000 back.
Right. And that's all it was. So it was only, and I just wonder, sometimes you find out these plaintiffs weren't so organic as we did in Roe versus Wade. She was not the organic petitioner as they claimed to be, but rather there was an entire conspiracy to create this case. And I'm just saying that this is weird, and I wouldn't rule it out. I would not rule it out why this happened. This is very bizarre. As if you wanted your
okay. Now
that you would sacrifice a win to make a point.
They did win. That's my point. They did win. They got what they wanted. We'll get to that. I think that the Moors, the people who financed the Moore litigation, they didn't get made much, but I think they did win, and I'll get there in a minute.
All right, John.
Abroad.
All right, be sure to let's stay on. Let's keep going. All right, let's get to that point, John. All right.
Yeah, next. All right.
Here we are.
Now, first of all, I think we need to be clear that there's 4 decisions here. Okay. Now, remember, okay, the question that's being asked here for the court to deal with is whether whether there has to be realization for income to be constitutional. Now, I know people would quibble with my characterization of it, but that's what it really is. Okay, leaving aside all the historical nonsense, right? Does there have to be realization in order for it to be income? Now, the first decision, which I call the Kavanaugh Five, okay? These are Justices Kavanaugh, Roberts, and of course the three Democrat appointees, okay? Two appointed by Obama, one appointed by Biden. Now, what they did was interesting, okay? Now, remember that this is a tax on income earned by a controlled foreign corporation. They said, well, because there was income earned by the foreign corporation, there was income realized. It doesn't make a damn that the Moors are being asked to pay tax on income realized by somebody else. There was income realized. So we are not going to consider the question of whether there has to be realization or not. Why? Because there was income realization. What we will consider is, whether it is reasonable to attribute the income of the foreign corporation to the shareholders. And what all five of them did was said, yeah, well, now remember, they're not considering retroactivity right now. They're not considering.
Right. They got out of that. They helpfully got out of that. Yep.
Oh, well, how is this different from normal Subpart F income? How is this
very different?
I agree it is. But this is their reasoning.
Right.
They say, well, this is no different from anything else. And you may remember Justice Elena Kagan, almost proudly and patriotically proclaims during the argument, here's what she says: this country has quite the history of taxing earnings of foreign corporations, or attributing earnings. It was unbelievable.
She's proud of it, right? So go ahead, go ahead,
Anthony. Let me finish on this. So what happens is they say, well, we're going to uphold the transition tax, but then they go to great pains to say, but we're not going to take a position on realization or anything else going forward. And here's at the end of the decision what Kavanaugh writes. Right now, remember, we're going to let the government keep its money. That's the most important thing.
Yeah, there you go. Right, we're going to have the right result, right?
Tax, but we're not going to take a position on whether realization is required. All of it is summarized by this. That said, we emphasize our holding today is narrow. It is limited to one, taxation of the shareholders of an entity. Okay. Two, on the undistributed income realized by that entity. Okay. Notice it says realized, right? Three, which has been attributed to the shareholders. Then it says four, when the entity itself has not been taxed on that income. Now they should have added tax by the United States, because maybe they're unaware.
Yeah.
That corporations,
they're not aware of other countries' tax, right? There's what other countries' tax? No. We're like taxing authority.
Okay, that's
right.
a different.
There it is.
Remember, taxation is an American invention. Then they end by saying, in other words, now this is hugely significant, and I haven't seen anybody comment on this. In other words, our holding applies when Congress treats the entity as a pass-through. What they have just done is said that CFCs are pass-through entities.
Oh my God!
I've been saying for years that this whole nonsense about changing to territorial taxation for court was such a big lie, because at the same time they did that, they created the guilty rules to tax them first. Anyway, you can't make this up. Okay, so they're the Kavanaugh Five, and
they're the Kavanaugh. And if you're just joining us, this comment from Suzanne. Good morning, Suzanne. And this is rephrasing where we've just been. The Moors dropped the retroactivity argument, which was a clear winner. And it seems as if their financiers wanted to get the Supreme Court to reel on the realization requirement. They didn't want to give up this challenge. They didn't want to give up the win on the transition tax for a larger strategic win overall. And what they wanted, but we'll get to that in a little bit. Next slide, John.
Next slide. Okay.
Next slide. All right.
Now, unpacking this decision, it's very, very nuanced. And, in all of these articles that say, 7-2 loss, etc., I think are wrong. But anyway, here are the various things that are going on in the case. First of all, it's definitely a 7-2 decision upholding the transition tax. That I would agree with. Okay. But it's a 4-1 decision upholding a realization requirement for income. Now, the reason it's 4-1 is because you have 4 judges. Okay, you have Barrett, Alito, Thomas, and Gorsuch coming right out and saying realization is required. No, full stop. That's it. Realization is required. You can't go, deeming income events and stuff like that. Against Justice Jackson, who wrote separately for the sole purpose, as far as I can see, to express her view that realization was not a constitutional requirement for income, adopting as an administrative convenience. So here where we are. 5 of the 9 judges took a position on whether there was a constitutional requirement of realization. 4 say yes, 1 says no. 4 specifically say they're not going to say anything about it. So therefore, I think that as it stands now, this is a 4-1 decision upholding a realization requirement, which means, and we'll get to this in a minute, the 877A exit tax is unconstitutional. Everybody, we'll get to that in a minute. The 877A exit
boy. Oh boy.
Half the stuff in the Biden Green Book is unconstitutional, but more on that later. Now, what all this would mean is that you would only need 1 of 4 judges, Kavanaugh, Roberts. There's no way that either Kagan or, and it's hard to say. Remember that no other judge was willing to join Justice Jackson. That no other member of the Kavanaugh 5 was willing to join Justice Jackson and saying that realization was not required. So all you would need is 1 more judge, and you've got a Supreme Court majority saying that realization is required. And to me, that looks pretty good. Side note, make sure you don't vote for the Democrats, okay? Because of the power to appoint these judges. Okay, now, then the next part of the decision was interesting, assuming realization of income. Okay. Now, remember that Gorsuch and Thomas struck this down just flat out. That's it, okay? Barrett and Alito, although they agreed with the majority, were willing to consider the whole issue of attribution. And what's fascinating here, Anthony, is that I believe in Justice Barrett's decision, she even raised the question of whether Subpart F could be unconstitutional because of unreasonable attribution to the shareholder. Right? So this is amazing stuff, right? So there we go. There's a lot going on in this decision, a lot. It's certainly not, 7-2 upholding the transition tax, although it would include that. All right, continuing.
Well, I guess this is my problem with these kind of decisions when you do this, is because you create it seems like something too clever by half. Like, oh yeah, we snuck in we might be able to claim a realization requirement. There's actually an actual realization requirement which would undo Subpart F, because it would undo the exit tax. It would undo a whole bunch of things. And so there's certainly some fodder for someone to reach that conclusion, but we find again and again, these good things that we're looking for in the future never happen, but the bad things certainly do. And so, okay, I could read through these tea leaves and see, and I would imagine that Justice Thomas would hop aboard to say, yeah, you know what, we're going to require realization. So the fact that there's this underlying current of a Supreme Court that would demand realization could happen there. But you know what didn't happen? That didn't happen here. We didn't get any clarity. All we got is a jumbled mess, which allows anybody to say more stands for anything they want it to be. There's this and there's this. But at the end of the day, the retroactive tax on income you never received was deemed to be constitutional by people who aren't quite aware. They don't be quite aware that the Moors are actually people and not corporations, or that even people
Anthony,
exist.
that's of course right, and that's why Americans abroad are the big losers, and that's why I think they need to get out of U.S. citizenship as quickly as they can. Okay, that's my view of it.
Yeah, yeah.
And I don't think it's very nuanced anymore at all. Okay, because as we discussed previously, Americans abroad are just one omnibus bill away from a revenue offset provision that will destroy their lives. Okay, that's what they are. Anyway,
all right. You know what, guys? I'm wondering here because you have a lot more slides here, and we are about up on time. So I'm wondering if we should. I mean, we actually maybe just pick this up where we are because there's still a bit more to go through, or do you want to try to power through? You have a lot more, and I think what you have is you really, you pulled out the various camps a little bit more in this. So do you want to power through, or do you want to do a part 2 perhaps on Wednesday?
I'll leave it up to you, or we can do both. We can power through quickly and do a slower version on Wednesday.
All right, we're going to power through. All right, I think we can power because I think we could power through because we set up the framework. I think in order, and we've also covered some of these a little bit. So let's go through. Okay, so here the ruling number 1 from the Kavanaugh 5. Here we go.
5. Now the key is they assumed there was realization because the foreign corporation realized income. Therefore, they specifically did not consider whether realization was required.
Oh,
right. Anyway, they said it's really just like subpart F. Again, notice that by not considering retroactivity, it's so easy for them to get there. So that's the Kavanaugh.
Right. Yeah. Next. Yeah. Okay, that's the Kavanaugh 5.
Yeah. Ruling 2, Justice Jackson, very short opinion, flat out. Nope. Realization is not a constitutional requirement. That's it. 3. And she was part of the Kavanaugh 5. Now, this is by far the most interesting decision, and there's a lot in it. Now, most importantly, they ruled that realization is a constitutional requirement, but they also were very, very strong on the point is that if there's a realization and it's going to be attributed to somebody else, there's a very significant layer of factual analysis to determine whether the attribution itself meets constitutional standards. Now, you may remember in the actual oral argument, Justice Barrett was asking that question specifically. Where does the 10% requirement come from? Is that reasonable, et cetera, et cetera? That said, I have no doubt, based on things that she said that I did not include in here, that she would generally include say 100% owned small business corporations of Americans abroad. Because of the 100% ownership, I'm convinced that she would think the attribution was constitutional. So good news, bad news, okay? Now, why did they not consider the retroactivity issue in the context of the due process argument? Because they said, well, the Moors abandoned it. The Moors abandoned it. Otherwise, we would have. Right? Which is just, Barrett.
Who are we? Or how could we? We're just these humble Supreme Court justices. What are we to do about it?
Which allowed them, to, let the government keep the money, keep the transition tax.
Just conveniently, yeah.
It's about the future. 4. Ruling 4.
Right. Ruling 4.
Thomas and Gorsuch. Tom, I think that, oddly enough, these are by far the most principled decisions. Okay. They just call it like it is. This is total bullshit. Okay, this is not realization, because what they say is, if I'm reading this correctly, and they're not as strong on this as I think they could or should be, but there's a quotation. The Moors are correct. 16th Amendment incomes include only income realized by the taxpayer.
Not somebody else. By the taxpayer. Right.
Now you may remember. In the hearing itself, Gorsuch had an exchange with the Solicitor General on this very issue as well. Then they go on explaining why the transition tax is not analogous to subpart F. And the Thomas decision does make reference. He doesn't use the word retroactively, but he does talk about the taxation of past earnings, which is, I think, basically the same thing. So there's your 4 rulings. Okay, next.
All right.
Here's what I think the decision means and why I think that the Moore litigants are probably out proclaiming victory. They won, I think, on the issue, or they arguably won or on the road to winning, okay, on the issue that matters to them, that is that income requires realization. And remember, 4 judges said it did, 1 said it didn't, 4 took no position. So, I mean, if you were to ask what's the Supreme Court's view on this, well, the current view is 4-1 in favor of realization, right? I mean,
that's right.
That's
currently.
Okay.
And I think that we could, wait a second, but I mean, if we look at Justice Thomas's, hang on a second, let me go back a little bit here. What is it? Did I go by
Thomas
it?
Ruling for.
Okay.
Yeah.
Okay. Well, the Moores are correct. 16th Amendment incomes include only income realized taxpayer. But did you include them in the 4?
Yeah, I mean, here are the 4 who say that there's a constitutional requirement of realization. Thomas.
Okay, which 4 are those? Yep.
Well, they're Thomas.
Okay, I see. Okay, you did put it here. Okay.
And Barrett and Alito. Those are the 4.
Okay, so Thomas was part of that. Okay, great. Thank you. Okay, got it. Okay, and so then we have
4. So I mean, I see this as I think that I mean, there's no way that counsel to the Moores and the people who funded this thing could see this as a loss. No way. Now, not as strong of a win. With the ideal.
Yeah, no, not really. Yeah, right. It's one of those wins that's not very operative, so we don't know what we call that exactly.
Well,
right?
I mean, the media is going to understand it as a loss, but that's not what happened here at all. Now, my point in terms of the world of Americans abroad, and I'm not the only one who thinks this, by the way, but the ruling in Moore. Now, remember, so if the position is that you have to have realization for income to be taxable, right? And the exit tax says on the day before you renounce, we're going to pretend that you sold all your stuff, even though you didn't, and you didn't realize anything. Then there's a strong suggestion, okay, that would be unconstitutional as per this decision and as per other articles on this.
Well, John, for some way, as you're explaining the exit tax section 877A, as you said that, it's like, well, that what that sounds exactly like a wealth tax. It sounds exactly like a wealth tax.
Well, that would be the position of Justices Gorsuch and Thomas. Okay, but regardless of the reason for it, okay, whether it's the point is that if to be taxed as income, there needs to be realization. Okay. I mean, then the exit tax is, I think, very problematic. Now, remember, the reason that the transition tax challenge failed was because the foreign corporation realized income. So they didn't have to get over the realization hurdle, right? What the majority did was said, well, the foreign corporation realized income. So the only issue is whether it's reasonable to attribute that income to the Moores. In the case of the exit tax, there is no realization of income, period.
Right.
The question is simply, can they do this given that nobody's received any money? And I think that the 877A exit tax is very vulnerable to challenge. And I think the challenge needs to come out the gate right now, right after the Moore decision. So if anybody's listening to this, is there a covered expatriate out there subject to the exit tax who'd be willing to be a plaintiff in a lawsuit? Get in touch with me if you are that person.
And if you are that, let me get John's. That's a very important. That's incredible. John, let me get your contact information up here right now. So here, you can reach out to John at citizenshipsolutions@protonmail.com. And John, my new firm I'm at, I might have somebody. I'll look around to see if we have someone already. We have a lot of people renouncing, and even my own firm, I'll check around to see if there is somebody who has usually we're successful at avoiding the exit tax. That's the thing. You just have to do a bunch of, that's the problem. That's the problem. We don't have any clients who pay an exit tax. So that's the problem that we have. So if you did pay an exit tax, reach out to John. That would be wonderful. And I think you laid out your case, John, pretty well. I think here, what do we have for sites? I think we have some more. Oh, say, here's our first
Here we go.
concluding thought.
In summary, one, a huge loss for Americans abroad, almost incalculable. This has destroyed many of their lives. I can't emphasize this enough. Get out, okay? Get out. Two.
You can get out, yeah, if you can.
I repeat, to the extent that the court addressed the realization issue, it's 4-1 in favor of realization, okay? True, there's not a majority of the Supreme Court, but there is a majority of the Supreme Court justices who considered the issue, right? Next.
It's
even Professor Aviona, okay, wrote an article prior to the Moore decision coming down, identifying the 877A exit tax as particularly vulnerable on the realization issue. So there's just a link to that. Okay.
Even a learned, pensioned intellectual?
A tax prof has difficulty finding anything in the world that's not taxable, okay? I mean, need I say more? 4. Very good article. I can't remember. I should have put the guy's name in it for a shout out.
I have it up. I do have it up. I can screen share it because I was reading it before, and it was
a good article on the Moore decision generally, but he also references the idea that the 877A exit tax is subject to challenge.
Yeah, and so this is. Let me get. I was just reading it. I mean, it goes on, and I think this is. Here it is. Mark Berg.
That's the 5th one. That's the 5th one I want to get.
Oh, the 5th. Oh, okay, sorry, but
go back to concluding thought 5.
All right, hold on. Let me go back to this one.
Okay,
concluding thought 5.
Let's
okay,
go back to 5. Now, I do not know Mr. Berg. I do not know him. I have never met him, and I was not even aware of him until I read a fabulous amicus brief that he filed in the Moore case, which basically, distinguished, was making the same point that I was making, which was that the difference between the transition tax and all this other stuff was the retroactivity, the taxing the past earnings, et cetera, et cetera. It was a very, very good brief. But I found another 1 or 2 things that he'd written. And one of them is in 2012, he writes an article talking about this very issue, right, that the exit tax might be unconstitutional for basically the reasons that I've been talking about. And I think that this is a very, very legitimate challenge. I think it should be rolled out the gate as quickly as possible. My God, there's even academic support for it. Unheard of.
Well, yeah, I don't even understand it, and it's nice to see that it's really nice to see this article written by a fellow attorney in New York, because it's quite good. And now here's the one problem with it, and this is sort of the problem with all of it. As I'm going through this and I'm making sense of his article. Okay, well, I'm an attorney with 20 years experience of taxation and the Constitution. And honestly, it's a very difficult for me to quite grasp the reading, first time. It takes time to go back. What did he mean by this? Oh, what did he mean by this? And going back and seeing how the context of words changes. And this is sort of the ultimate sort of, where we are as a country is that, look, the basic instructions to Form 1040, they're written to the 9th, 11th grade level. Okay. Your average American has a reading comprehension of a sixth grader. Okay. So we could say that at least more than half of the country can't even understand the basic things. And now as you get into more complicated areas of taxation, we're losing fewer and fewer people. And in fact, what has to happen is some of the smartest people in our society must be recruited into trying to decipher and understand and communicate and give actionable advice to people on this. And so how could this be a result that anyone ever intended? That the law became so convoluted and complicated, the Supreme Court can't have a unified opinion on a retroactive tax on someone else's income. They can't even give you a unified opinion that's actually actionable. We don't know what to do. One action we want to take is perhaps there would be a claim to make the case that Form 877A or the 877A exit tax is unconstitutional. This is so far beyond the comprehension of the regular American that in a way you could say it's a coup d'etat. It's a coup d'etat on the American people because you need to be a member of the clerisy to interpret these various things and to give the advice to people. And that's not what anyone ever voted for. That's not what we ever voted for. That's not what the purpose of the Constitution was. Look, the American Empire was part of the Constitution, but making an American empire that was not understandable to the people it claimed to be rule over, that wasn't what it was a part of. And this is where we are. We are here because, and this is what I would say too, is it's also, look, constitutional review is something invented by Justice Marshall. And when he did so in Marbury versus Madison, he didn't do it directly. He didn't come out and say it, but rather it's a sprawling, passive aggressive opinion that claims power that wasn't there. And it had to be passive aggressive because the power wasn't there. And that Justice Marshall is the same Justice Marshall who is worshiped in every law school. And everything that he does is like, well, that's Justice Marshall's our hero. Why is that? Because he gave power to the Supreme Court, power that wasn't there. And we look at that as a good thing. Well, this is all a natural result of just what Justice Marshall did. And unfortunately, attorneys look at this as Justice Marshall as a hero, when the last thing he wanted to do was to be clear. Because if he was clear, no one would stand for it. And that's what we have here. Nothing is exactly clear. And if it was clear, if people did understand what was going on, they wouldn't stand for it. But everyone is in a position where they can't understand it. Therefore, how do you raise an argument against something you can't understand?
Well, there's that, and there's also the money, but there's also the problem, okay, that, obviously the 877A exit tax only affects a minority of American citizens who renounce U.S. citizenship, okay? Not only are they a barely discernible minority, but to the extent that anybody has opinions about them, they're hated. I mean, to enter into your constitutional discussion here, okay, Americans are broad, are, I think consistent with Justice Stone's discrete and insular minority in the Carolyn Products case, right, from like 1949 or something. And this is part of the problem. But again, this is why they've got to get out of this, okay? I mean, we're in a situation where the court won't even consider them when numerically they're the largest number of people affected by this, where these groups that are supposed to be trying to help them will not lobby for the only thing that matters, severing citizenship from tax residency.
Yeah.
Get out.
Get out. And with that, let's go to one final comment, which brings us back full circle to getting rid of citizenship-based taxation, because Trump announced that he would, and I did see this, and thank you very much for reminding me, because this was exactly why that triggered in my mind that, hey, wait, CBT may go away, because, hey, before the U.S. income tax, the U.S. government got all its revenues, most of it, excise taxes on alcohol and tariffs. That's where it comes from, and that appears to be what a constitutionally permissible tax is. Now, the warning I would have on that is tariffs aren't necessarily the solution that they automatically assume to be, because tariffs can be weaponized, and in fact, they have been in this country. And actually, that is what led to the Civil War. Lincoln insisted on a 25% tariff on imported goods, and more importantly, he insisted on a 50% tariff on anything containing steel. So in the South, where they didn't manufacture their own farming equipment, all the farming equipment that they imported from around the world was subject to ruinous taxation, and that put the South in such a difficult place they could not pay that tariff. So that's what we got to watch out for. And then that led to the destruction of our country, and then the federal government claiming more power over us. So we want to be careful. I think tariffs can be a good idea, but the whole idea is that we want to make sure we have reasonable taxation, just reasonable, keep them reasonable. And I would say that is that, when I'm listening to him, I do hear those things, and I am still not holding him responsible truly responsible for the transition tax, because I don't think he quite understood it, and it was something that was going on in existence far before he was in office. It was part of a larger scheme of things, I believe, and it was presented to him as a good thing, as it would allow. I don't know. He was looking at it as a good thing because it would allow these foreign nationals to repatriate money into the U.S., which he said, hey, that's a good thing. Did he pick up on the fact that individuals would be necessarily screwed on income that they never received? I don't know. I don't know. But I would say, I would say this, I am definitely more hopeful. I am voting for President Trump for sure, for his tax policy. And again, the justices that did rule on the correct side of this one were all appointed by Republicans. And so I think that's something, indisputable. So hopefully that answers your question. John, your concluding thoughts on this, and we have a podcast coming up on Wednesday.
The income tax. I don't think that look, obviously, what's the difference between, say, the fair tax or raising revenue through tariffs and the income tax? The income tax provides a vehicle for the government to regulate people's lives, to punish them at will, all right, and basically keep them in, pretty much a permanent state of terror. So the question is not, does it make sense for the country to have the fair tax or something? The question is, does it make sense for the government to allow Americans to be free? And the answer is obviously not. Okay, I mean, the country is at this stage in its history the antithesis of freedom. Okay.
Yes. Correct.
And it's going to require, I think, a revolution to get that back. But the reason why, this continues, I mean, let's be clear, it's not the government. It's the actual American citizens who buy into the stuff. Why is it so difficult to get change for taxation of Americans abroad? Why? Because a majority of American citizens abroad are perfectly comfortable with CBT. Many of them love it, and we know that the national anthem for Americans abroad is "My Country, CBT, Sweet Land of Liberty. We love our forms."
Well,
there's the problem.
And I got to say, I really appreciate this comment. A new viewer today. Thank you so much for. I'm not sure how to pronounce your name there. The Ahmed Vienna. I really want to thank you for this, because you actually your comment and on tariffs. I just read something right before this show, the article that by Attorney Berg, and in this he's really saying this is the difference between direct and indirect taxes. Indirect taxes aren't as bad because they won't control your life. If you want to avoid an indirect tax, you can. It's the direct tax that you can't avoid. And when we get to the issue of consent, that's what's pretty critical. And I would say this, the fair tax, which I'm not a huge fan of because it's a 25% tax rate. Really, the problem with the government is there's too much government. So I don't think the government needs a 25% sales tax rate. But what I do like about it, and this is what the guys say about it, and I'm like, okay, I'll give you this, is that, well, it only applies to new goods. So if you don't want to buy something new, you don't have to pay the fair tax. Well, now that will increase the cost of things that are used, but still, it gives you a potential way out of it. Whereas, look, if the government is just going in there and claiming income that isn't yours, you've never received, is something that you need to be taxable on, was like, well, we don't have a control over anything in that case. There's not one thing we really can control in that. Just our mere ownership of something is the justification to have our wealth taken away. So that's really, I think, and I want to read this article a little bit more and get into it a little bit more, because this explanation between direct and indirect taxes and along how the 16th Amendment interplays isn't really clear. And that's why I think this is I'm really this article I'm looking forward to reading a little bit more in depth. And maybe I can find Attorney Berg if anyone knows it. Tell him, I'm a huge fan and wouldn't mind. I think that would be wonderful. He'd be a great guest if I could get him. So with that, we're going to conclude. I want to thank Keith Redmond for joining us today. He had to drop off the call. We were going a little bit much today. Keith is the advocate to consulate to Americans abroad. So if it is something you're thinking about renouncing and you're not ready to pull the trigger on calling a tax professional or a professional like myself or John, you can reach out to Keith. You can send him an email at US_overseas_advocate@outlook.com. Now, if you are someone who says, you know what, the time to renounce is now. There is no U.S. citizenship, reach out to John Richardson at citizenshipsolutions@protonmail.com. And now I just say for myself, if you do have an offshore issue you want to clean up, you need to get in a streamlined disclosure. I am joined a new powerful firm, and we have a lot more capabilities than we did right now. And you could reach out to me, same place. So you can go to irismedic/offshore to reach out to me and schedule a time. Same place. I am now at Thavot and Partners, and it's exciting. And we're seeing more of the issues affecting very wealthy individuals, and the fascinating issues that we're working through there, having a lot of fun. So again, if you want to look into that, just reach out to irismedic.com offshore. And I would suggest, we had a great turnout today. I want to thank everyone for a great turnout today. And look, go into the real issues, because we're finding this is where the professionals and people so interested really want to dig down, and you want to get to the truth. And that's why you subscribe to this channel. You subscribe to this channel because you want real analysis by people who are really in the trenches. So subscribe. And then what I advise is turn on those notifications. We do try to go Wednesdays, not 7:30 Eastern, live, but we do pick up with news coming out. And Loper Bright should be up, I think, on Wednesday, and that's going to be a big one that should be out. So we'll probably cover that later this week. So again, be sure to subscribe and turn on those notifications so you know when we go live. This is Anthony Parent for Iris Medic. Thanks for watching.